Okay, we're at 2 minutes after the hour, so I think we're going to kick things off. I'm Ryan Parker, the Chief Legal Product Officer at SixFifty. And before we get going, I want to tell you just a little bit about who we are at SixFifty and what we do. Headquartered in the Silicon Slopes of Utah and powered by Wilson Sonsini, SixFifty is a technology company that brings the expertise of the top legal minds to your fingertips. Our technology is programmed to take on complex legal issues by providing customized contracts, policies, and documents to people and businesses. We continuously monitor dynamic areas of the law to update our tools in real time so you can too. Our customers enjoy the dual benefits of innovative technology powered by human expertise. Leave the law to us so you can do what you do best. The law is complicated. SixFifty makes it easy. If you'd like to hear more about SixFifty and how we may be able to help, let us know. You can put your name in the Q&A and we can respond there, or you can visit us at 650.com and request a personalized demo. So a couple of housekeeping matters. We hope this will be a really interactive webinar. We have a lot of attendees. We're going to have some polls. We'd love to answer your questions. So please put your questions into the Q&A. That will allow us to track them more easily. We'll also be monitoring the chat. So today we're going to talk about what to consider when you have employees working in new states. And I have two co-presenters with me today. The first is Adam Wright. Adam is a vice president of legal product at SixFifty. When he's not working, you can find him baking sourdough bread, listening to 1960s honky-tonk music, trail running, or skiing in the mountains outside of Albuquerque, New Mexico, where he lives with his wife, 2 kids, and 2 dogs, Lefty and Turkey.
Thanks, Ryan. Happy to be here today.
Awesome. And our other presenter today is Adrienne Jack. Adrienne Jack is a vice president of legal product at SixFifty and works primarily on employment products, including return to work issues. She graduated from Northwestern Law School and worked at the law firm Hogan Lovells in Washington, D.C. for 5 years doing corporate employment and tax law before returning to her home state of Utah and joining SixFifty. She enjoys Taylor Swift, warm socks, and a good street taco. And with that, we can look at the agenda and then I'll turn it back over to Adrienne.
Great. Thanks, Ryan. We are excited to be on this webinar today. This is an important issue that many companies are facing about hiring employees in new states. As the pandemic has been ongoing, companies are expanding in places they have never had employees before. And there are a lot of considerations to think about as they do so. So we're going to talk about 3 different pieces of what companies need to think about. The first is, what are the state registration requirements and other employment considerations to think about? The second is, what updates might be necessary to company employee handbooks to include required policies by the states where companies are expanding? And then the third item is, what are some changes that companies need to think about to tailor their offer letters and employment agreements to the new state law that they're using? So I'm going to get us started, and we would like to kick off with a poll question. We would love to know, in how many states does your company have employees? So we'll bring up that poll, and we'd love to know, do you have employees in just 1 state, 2 to 5 states, 6 to 10, 11 to 25, or more than 25? And those poll numbers are coming in. This is very interesting. I think it differs a lot than what we would have seen 2 years ago. So we're excited to see where companies are right now. We'll go ahead and give you about 5 more seconds and then we'll close that poll. Great, looks like numbers are trailing off. So we'll close that in 3, 2, 1. Okay, let's see these results. Okay, interesting. So it looks like the 2 to 5 range, 6 to 10, and 11 to 25 are kind of equally tied for how many states companies have employees. And that's a lot of states. I mean, if companies are thinking about even 5 different state laws, that's a lot to keep track of and to monitor. And then states with or companies with 11 to 25, that's a full-time job to monitor all of those changes in all of those states. We're very excited to delve into some of the things to help make this process easier for companies. So the first issue we want to talk about is when companies are thinking about hiring an employee in a new state, so they haven't yet done so, but they're recruiting employees in a new state, what are some employment law considerations those companies need to think of? What are some hiring parameters that limit what companies can do as they're recruiting new employees? So there are different limitations based on the states that the companies are expanding into. These include limitations on inquiring about criminal history, requesting credit reports, obtaining background checks, and limits on drug testing. So some states have different standards for what companies can ask about and consider with regards to a potential candidate's criminal history. Some states have very limited standards, but other states like New York preclude employers from inquiring about or taking adverse action against potential candidates for charges or arrests that didn't result in a conviction. So they must result in a conviction for employers in New York to be able to consider that in their hiring process. Also, New York law prohibits employers from taking adverse action based on a candidate's criminal history unless those criminal offenses are directly related to the specific job or license being sought. So companies really need to think about how they could take a candidate's criminal history into account if they're looking at a candidate from New York. And that might differ from looking at a candidate in another state on how they can take those factors into account. Other considerations such as limits on credit reports. So all companies have to follow the Federal Fair Credit Reporting Act, the FCRA, to check an employee's potential credit report. This requires employers to obtain consent before getting that credit report on an employee and to give a candidate a warning and a copy of the report if the employer is going to make a decision based on the report that they've obtained. But in addition to that requirement that all companies have to follow, at least 10 states have passed laws prohibiting employers from obtaining credit reports or restricting how and when they can use those credit reports in making hiring or other job decisions. And more than 20 states are currently considering similar legislation. So this is on the top of mind for a lot of employers. If obtaining credit reports is part of your recruiting process, companies really need to think about what are those limitations and how do they differ by state. So after a company has decided to move forward and hire an employee, we'd love to talk about next, what are the considerations a company needs to think about as they're onboarding that new employee in a state where the company hasn't previously had employees. So before we dive into this, we'd love to ask another poll question about what is your biggest concern when considering whether to hire an employee in a new state? Is it the registration requirements that might be necessary, payroll issues such as the frequency of pay requirements or how that implicates that, tax implications like sales tax and income tax, the paid leave and employment policies required by an additional state, or a different consideration not listed here? All of these can have big implications for a company, and all of these are important issues to consider, but we'd love to know kind of what are the deal breakers for your company, or what are the biggest items that you think about when recruiting an employee in a new state. Okay, we'll give you just about 5 more seconds on this, and then we'll end the poll. I'm anxious to see what companies indicated. Okay, we'll end that poll in 3, 2, 1. There's a couple last minute votes, so I hope we got you in there. Okay, interesting. So it looks like registration requirements are one of the biggest concerns that companies are thinking about. And that's something we're going to talk about more on this webinar, what that entails, how it might differ from state to state, as well as tax implications. That's a huge issue, especially for companies that might trigger a sales tax obligation in a state they haven't had sales tax obligations before. And then paid leave and other employment policies is huge. Some states have a wide spread of required policies, which we'll talk more about on this webinar. So that's definitely something that affects companies as they're hiring employees in new states. Okay, perfect. So the first item we want to jump into is what are the registration requirements? So once a company has decided to hire an employee, what do they need to do to onboard that employee in a new state? Payroll companies can be helpful with part of this process, but many of the tasks must be handled by the company because it requires setting up an account or obtaining an account number for the company, and payroll companies often won't handle this. The first item, which is often a gatekeeping one, is registering to do business. Many states require that companies register to do business in the state before they can obtain different tax accounts or really proceed further for onboarding an employee. Registering as a foreign employer in that state usually requires the company obtain a certificate of authority in that state. And it also may require the company have a registered agent in that state as well. Unfortunately, many states haven't made this process electronic, and it still requires companies to mail in a form to a state agency and then receive a certificate of authority from the state agency. And this is often something companies need to get ahead of, because it may take time to get that certificate of authority and can often be gatekeeping to proceed with the next steps in the process. So as soon as a company decides to hire an employee in a state, they need to think about, what are the registration requirements? What do we need to do to register to do business? Do we need a business license, a certificate of authority, and then really start on that task right away? Next, companies must register for different tax accounts. The first is often withholding accounts for states that have income taxes. We know states like Alaska, Florida, Tennessee, Texas, Washington don't have a state income tax. So this only applies in states that have income taxes. And it's often done through the Department of Revenue. Employers have to obtain a withholding exemption form from the employee to know how much of the employee's income to withhold from their taxes. And then once this withholding account is established, the company usually provides this account number to the payroll agency, and then they handle the ongoing payroll withholdings. And hiring an employee in a new state often has sales tax implications. Companies need to obtain a sales tax permit or license and complies with sales tax laws where the company has a nexus, which is a key word. And that means the company has some connection to the state. Prior to 2018, companies needed a physical presence, such as an employee or an office or inventory in a state, to be subject to sales tax in that state. However, then due to this US Supreme Court's decision of South Dakota versus Wayfair in June of 2018, companies no longer needed a physical presence in the state to establish a nexus there. Companies could have what they called an economic nexus, and they no longer needed a physical presence to trigger that sales tax obligation. So there are two ways now to have a sales tax nexus in a state. One is an economic nexus, and the other is a physical presence. After the Supreme Court decision, all 50 states implemented laws indicating what constitutes an economic nexus in their specific state. A lot of states established revenue thresholds of the amount of dollar sales in a state. So the range typically is about $100,000 to $500,000. So states indicated that if a company has $100,000 or more of sales in that state, then they have an economic nexus there and need to collect and remit sales tax to the state. So if a company doesn't already have an economic nexus in the state, if they have an employee there, that company will become subject to sales tax because they have a physical presence, which triggers that sales tax obligation. So the company would need to register to obtain a sales tax account and remit sales tax in that state. And there's another layer of complexity to this, and I'm sure all of those people who do sales and use tax know about these complexities, but certain kinds of sales, such as the sales of services, are often exempt from sales tax in states. So some state laws differ by industry or the type of product that is being sold to determine which sales are taxable and which sales are exempt. So even if the sales are exempt in that state, by having a physical presence there, the company will still need to register and file periodic sales tax returns indicating that there are no taxable sales in the state. So this is a tricky obligation, and companies need to think about this and think about the implications of cost to the company of having an employee there. Because if a company has sales in a state that they haven't been paying sales tax, by having an employee there, they then open all of those sales to be subject to sales tax in that state, and it can be a significant cost to a company, which is often a factor that companies look at when hiring an employee there. Internally, the company will need to update its invoicing system to indicate which sales trigger sales tax in that state and tag them accordingly. Okay, and there are also unemployment insurance obligations. States have different laws about when unemployment insurance is required. Some states say if it's one employee, some states say if you have 5 employees, but the threshold is usually pretty low, and you need to usually register with the state. Sometimes it can be coupled with another registration like a sales or income tax registration. Other times it's a separate process to register to withhold. taxes, and then also pay unemployment insurance in that state. Okay, let's jump back a slide. I jumped over a few items that I'd like to talk about in there. So there are different types of employment registration that the company needs to do. After registering to do business, the next item can be registering with the Department of Labor. This includes reporting the new hire. The Personal Responsibility and Work Opportunity Reconciliation Act is federal legislation that was implemented jointly by federal and state employers. And what that act does, it requires employers to report the data on a new hire within 20 days from the employee's start date or their date of rehire. And the goal of this act was to obtain payment for child support orders, since wage withholdings are the primary method to enforce those for non-compliant parents, and also to reduce the fraud in government benefits or for unemployment and workers' compensation. So this law is a federal law, but some states have different requirements on how soon after a hire that the company needs to do that, or the registration process might look different from state to state. In one state, it might be registering with the Department of Labor. In another state, it might be required to file with a different agency. And there are two main ways to satisfy this requirement. First, the employers can just report that new hire in the state that they just hired an employee. So if you're a company that's headquartered in California and you hire an employee in Ohio, you would just go to the Ohio Department of Labor and register that new employee. Another option is what's called multi-state reporting. And that's where the employer selects one state and registered all of its employees there, but then it notifies the US Department of Health and Human Services that all of its employees are registered there, but they may be working in different states. And that's a different method. So companies need to specifically register to do that. And that could obviously be beneficial if companies expect to be in a variety of states. It could be a lot more efficient for the company to do so. But if a company has already registered its employees in 3 different states, it might continue with that approach because that's the approach they're currently using. And next, a small item to think about is just to make sure that the company's workers' compensation coverage includes that new employee that's been hired. That means companies might need to contact the broker and make sure that that coverage can apply to an employee in a new state. And then another consideration, which can be very significant in some states, is a company might need to register with paid family and medical leave authorities if there is paid family leave in that state that requires state registration. So for example, in Connecticut, the Paid Family Leave and Medical Act allows employees to take paid leave for life events under the federal FMLA, the Connecticut Family and Medical Leave Act, or the Connecticut Family Violence Leave Act. So employers that are hiring an employee in Connecticut would need to register with the Connecticut paid leave. They would need to then withhold 0.5% of the employee's income from their payroll deductions. So this requires a specific registration that companies need to do from the outset to onboard that employee. And so this could be helpful after, as Ryan will talk about, after a company determines what laws are applicable in that state or what leave is required to be provided. If the company sees there's a paid leave requirement in Connecticut or in another state, they should delve into that and decide, okay, is there a registration with a state authority that we need to do, or is it just something that we need to provide leave to employees, but we don't need to register with a state authority to do so? Okay, great. I think we're ready to move forward. There are other employment law considerations, and these can range from complicated to pretty straightforward depending on the state. The first one is whether the state allows at-will employment. All of the states except for Montana allow for at-will employment of employees. Montana has a wrongful discharge from employment act that allows employees only to be terminated for cause after they've been employed for a probationary period. And the Montana law defines what is good cause and reason for termination. But in Montana, that's a significant obligation because companies need to think about the probationary period and clearly communicate that to employees, and then also be prepared to keep employees until there's reason to terminate for good cause. Another consideration are the implications from being exempt or non-exempt employee. Some states use different criteria to determine which employees are exempt and which employees are non-exempt under the Fair Labor Standards Act. Many states look to the employee's job duties and whether the employee is paid a salary and the amount of the salary that the employee is paid. Employees who are non-exempt have to be paid at least the minimum wage and must be entitled to overtime which is calculated according to state law. So many states follow the FLSA, the Fair Labor Standards Act, and dictate that non-exempt employees are paid 1.5 times their regular rate of pay if they work more than 40 hours a week. But other states have different requirements of when overtime is triggered. So in Colorado, for example, employees must be paid 1.5 times their regular rate of pay for any work in excess of 40 hours per week, or in excess of 12 hours per day, or in excess of 12 hours of continuous work, regardless of when the shift starts and ends. So there are different obligations regarding overtime in different states. And then similarly, the minimum wage differs by each state. Also, it could differ by state, by county, even by local jurisdiction. So employers need to think about what is the minimum wage in that new jurisdiction where the employee is working, both on a state, county, and local level. Some states have different minimum wages based on the type of work the employee is doing, the industry that the employee is in, or even based on the company's headcount. California has 2 different minimum wage laws based on the company headcount if the employer has 25 or fewer employees, and a different minimum wage if the company has 26 or more employees. Similarly, each state has different laws on how frequently employees must be paid. The required pay frequency can range from every 2 weeks, at least twice a month, or employees can be paid monthly. Some states have default pay frequencies, but that period can be extended if employers provide written notice to employees. For example, in Vermont, the pay frequency is that employees must be paid weekly, but employers can implement a bi-weekly or even semi-monthly payday if they provide written notice to employees. So companies need to think about that as they're onboarding employees in different states of how frequently are we paying employees now and what does that new state require, and make sure that their payroll systems align. Next, there might be required training in a new state. New York state law requires that employers with 1 or more employees conduct sexual harassment training for all employees. And the state has sexual harassment training that can be provided to that employee, but that's a requirement to think about that companies need to be prepared to provide and meet that requirement if they're expanding and hiring an employee in New York. As we all know, COVID regulations are constantly in flux, and they differ on a state level, on a county level, even on a local level. So this is something to monitor and think about. If a company is hiring an employee in California, for example, Cal OSHA has one of the most robust COVID-19 prevention laws currently in effect. And under Cal OSHA's emergency temporary standards, employers that have 1 or more employees in California that interacts with any other individuals in a work setting are required to have a written COVID-19 prevention plan. They're required to screen employees for symptoms of COVID-19, take certain measures if there is someone with COVID-19 in the workplace, and a multitude of other requirements that we address in one of our tools that we offer to help companies keep compliant with Cal OSHA. So that's something companies need to think about. If they're hiring an employee in California, they might need to update their COVID-19 policies and procedures, and they'll need to track these ongoing obligations in a whole new jurisdiction. Companies need to make sure that their insurance coverage can extend to a new state to cover that employee in a new state. And then lastly, one of the companies need to think about, and we'll move to the next slide for this one, is what are the labor law posters and required notices? The Federal Department of Labor requires employers provide posters and notices in the workplace. And there are also state signage that's required. I know California has over 10 required posters that have to be provided to employees in a workplace. And they typically have to be posted in a conspicuous location, but the US Department of Labor has indicated that those can be distributed electronically, because if you're hiring an employee in a new location, they might be working from home, and you might not want to, there's no way to post all those posters at their home. So there's a way to distribute those electronically, either posting them on a company intranet if employees regularly access it, or distributing it electronically is another way, as long as employees can continually access that information. So that's something to think about as well. And then all of this becomes even more complicated because it differs on a county and local level. So in conclusion, this is something that is complicated for companies. And you'll see on this last slide that you can think that you're covered on a state level, but then it also goes even more granular to city and local levels of what companies need to think about. And we can advance one more slide for just a minute. Here's some of those considerations. All of the considerations I just spoke of, they can differ on the state can have one standard, but a local level could have an even more stringent standard. So you not only need to think about the state law, but the county and local laws as well.
Shannon Law asks, do we have access to a list of where we need to register in each state on our 650 portal? And I think Shannon may be channeling the same wavelength that we are here. One of the reasons Adrienne knows so much about this is that she is in the midst of creating a new tool that we'll be offering to our customers that will help them to know where they need to register and the steps they need to take when they hire in a new state. So.
Yep. Our goal is to kind of put all that information in one place because it's complicated and there's a lot of things to think about. So if we can have one resource that employers can turn to address all of these different types of issues, we think that would be really helpful.
Yeah, there is a lot there. Thank you, Adrienne. And we'll save some of these other questions. You can answer them in the chat and the like, and we'll save some for the end. I'm going to turn now to employee handbooks. We've really broken up the considerations here into three parts. Adrienne just covered the state and local law requirements that attach when you hire someone in a new state or when you have an employee move to a new state. And now I'm going to talk about the employee handbook and what you need to be thinking about with regard to your employee handbook when you hire someone in a new state or when you have an employee move to a new state. And then I'll turn the time over to Adam, who will touch on employment agreements. COVID has changed the way that our workforce looks. And we now have workforces that are remote and dispersed. And because of that, employee handbooks can be more important than ever because employees can't just walk down the hall to the HR manager or talk to, stick their head into the office of their neighbor. And the way they're finding answers to their questions is often by accessing the employee handbook. And so the employee handbook, I think, plays a new and more important role in this remote and diverse workforce. The other thing is that employee handbooks can be much more difficult to update than they used to be. And that's really for two reasons. One, as we saw in our first poll question, a lot of companies have employees in multiple states. And I think that's a phenomenon that has really picked up steam during COVID. We've seen companies that used to have employees in one state that now have them in 5 or 10, or as we saw in our poll, there were some companies that had employees in more than 25 states. And because of that, updating your employee handbook can be difficult. Making sure that you have the requirements for each state where you have employees, and then staying current when the law changes in all of those states can be a significant challenge. And so while the handbook is more important and potentially used more often than it ever has been before, it is also harder to keep it up to date and to make sure that it's a useful tool. One of the reasons that this is important, and we'll move to the next slide, is that the requirements in each state vary widely. And so when you think about the type of leave you need to provide or the other requirements you have for your employees, that can vary significantly from state to state. And we have a tool that helps our customers to figure out what's required in each state. And this is just an example. If you're in Utah, which is where we're based, there's a relatively small list of state required policies. If you move to Nevada, that list gets a little longer if you have employees there. And then if you have an employee in California, that list more than doubles. And so depending on the state that you're in, the number of policies that you need and the type of leave that you need to provide can vary drastically and significantly. And so, this is something that can be tricky for companies because if they hire someone new in California, they may need to generate a whole host of new policies, or they may need to update other policies that they have. And so this can be difficult. As companies move into multiple states, and let's jump to the next slide, we're seeing companies choose from essentially 4 major types of employee handbook formats. And I think that this is interesting as companies are thinking about how best to present their policies to their workforce. One format is a universal handbook. That's one handbook that covers all its employees, and all the employees are governed by one set of policies. Generally, a company that has a universal handbook will choose very generous leave policies that meet the requirements in every state. And an advantage of a universal handbook is if they move to a new state, they may not have to do very much to update their employee handbook because they've already sort of set a very high standard for leave and for the other policies that they have. Another format that we're seeing is a state-specific format, where a company will essentially say, okay, here is our, for example, bereavement leave policy. If you're in Arizona, you get this number of hours. If you're in California, you get that number of hours. If you're in Nevada, you get this number of hours. And it lays out in the body of the handbook different state-specific policies that are based on the state-specific laws. And as we saw in the earlier slide, those laws can differ quite dramatically. And so that's another way to kind of keep all your policies in one handbook, but have them be state-specific. As companies get into more and more states, those types of handbooks can get very long. A third format that we see is what we call an addenda format, where a company may have most of their employees, for example, in California, with only a handful of employees, maybe in Arizona, Nevada, and Utah. And so they'll have a handbook for California, and at the back, they will have an addendum for each state that they're in. And those addenda will cover sort of all the state-specific requirements in the other states. One advantage to this format is that when a company adds a new state, they can relatively easily create a new addendum and add that just to the back of their handbook and into the addenda. And so that makes for, I think, a relatively easy process for adding new employees or employees in new states. And then finally, we're seeing some companies that just create multiple handbooks. They just have one handbook for their employees in New York, another for their employees in Connecticut, and a third for their employees in Vermont. And that allows the companies to really specify and focus their handbooks in on the state-specific requirements of those states. One advantage is that it's easy to change those handbooks when there are changes to state law. A disadvantage is that it can be difficult for an HR manager, for example, to make sure that she or he are keeping all of those handbooks up to date and are making sure that they're all accessible to employees. And so there are pros and cons, I'd say, to all of these different formats. And it's interesting, as we've had employees moving across the country, to see to which format companies have gravitated. And so we're going to ask just a quick poll question here about what type of format you use in your company for your handbook. There we go. So we've got our poll. And I'm interested to see, I think this is something that has changed pretty dramatically over the last few years. We're currently helping hundreds of companies with their handbooks. And so we talk to companies about employee handbooks all the time, and have seen companies that use each of these different methods. But I do think that there is one category that seems to be gaining momentum, and it'll be interesting to see if that's reflected in the poll here. So we'll give people just, and I think we have someone in the chat that says they don't have a handbook yet. That's okay. And that's something we help companies to create a first handbook as well. But let's just take 5 more seconds. We have a lot of people who have chimed in. We'll just give you 5 seconds here to get your vote in. We have about 125 people who have voted, so it's a big number of businesses here. Let's end our poll and take a look at what we've got. Okay, really interesting results here. Actually, this is a little different than I would have expected. 63% of our votes here are for a universal handbook. That's a handbook that just has one set of policies that apply to all its employees in all of its states. There's some real advantages, though, to that approach. And one thing that you avoid there is a situation where employees are looking at the leave or the benefits that employees get in other states and comparing, and they're upset because they don't get what their colleagues in California or New York get, for example. It also makes it a little easier when employees move to new states. And so I do think that's a trend that we're seeing. I'm a little surprised that number is so high, 63%. Really interesting. State-specific policies, only 8%. And I think that used to be a real trend, that was something that companies did fairly frequently when they just had employees in 1 or 2 states. But as companies get employees in, as we saw in our poll, 5, 10, 15 states, that type of format can become unwieldy very quickly. The addenda, 28%. I thought we might be a little higher there. We've worked with a number of companies that use that format, and I know that's one that we have heard some of our customers ask for, and we've recently created an addenda tool just for that reason. And then multiple handbooks, 1%, one out of it looks like 123 votes. So not a very popular option. I think it can be unwieldy and difficult to manage. And so this is interesting. I think it supports what we're seeing as well, with a lot of companies moving towards a universal handbook. Let's move on here and talk about updates. So the other thing that's hard is, you have your handbook and someone moves to a new state, and you have to make sure it's updated and the like, but then you have to continue to update your handbook. And that can be a challenge as for a couple of reasons that we're seeing. One, we're seeing more changes to state employment laws over the last couple of years, and we monitor those very closely. We put updates for our customers every month, and so we're watching the changes, and we've seen a significant uptick in changes. And so at the same time that states are having to monitor the law in more states, we're also seeing more changes, and I think that can make updating really, really difficult. Let me just also mention that keeping your handbook up to date is crucial, frankly. If your employees are relying on your handbook, you need to have policies that are consistent with state law and consistent with your practices at your business. When we were building our handbook tool, we talked to a lot of companies who told us that updating their handbook was really one of the biggest pain points for their HR team, that trying to keep it up to date often required them to set aside 2 weeks and gather people together in a room and try to update it. And a lot of companies told us that they had the best of intentions to update it every 6 months or every year, but that got pushed down the road because it was such an onerous task. And so we're going to ask another poll question here, and be honest with us. Our poll question is about how often you update your employee handbook. And so your choices here are every month, every few months, every year, every 2 years, and no consistent schedule. And I'll be interested to see kind of what we get here. I think that we've had a trend towards companies updating their handbooks more often, but it's still, and as we've touched on, it's still a really difficult process. And I think that probably slows down the frequency. And someone put in the chat there, just when there's a major update. I think we see that from companies. That's one we should add to our poll, when there's just when there's a major update. I'll put that under no consistent schedule, but that's a good one. Why don't we just take our last 5 seconds here if people want to vote on how often they update their employee handbook. Okay, we've got a lot of votes. Thank you so much. Let's display our results. So every month we have 1%. It's pretty diligent every month, and I'll talk about that in the next slide. Every few months, 6%. So we're really at less than 10% who are doing it, on a monthly or every few month basis. Every year, 35%. That's, I think, has been the industry standard in the past, was a yearly update. Every 2 years, 6%. I think that it's good to be consistent. 2 years is a long time when the law changes and when practices change. And then no consistent schedule. And I think that may also go to our comment that people are updating their handbook when they get significant changes. So that's really helpful and interesting that people are kind of not using a consistent schedule. Why don't we jump to the next slide, and we'll talk just a little about updating. Because handbooks have become so important and updating them has become tricky, what we recommend is that companies create a plan to keep their employee handbook up to date. And it can be a plan that fits the company. We recommend that companies at least look and review their handbook on a regular cadence. At SixFifty, we put out an update on a monthly basis to our employees, and we summarize the changes in the law to kind of help them. And we encourage them that if there are changes in our update that affect their handbook, to just make the changes that month and not to wait. And that way, the idea is you put a few minutes into updating your handbook every month. And at the end of the year, you don't have to have a big effort at the end of the year because you've kept your handbook up to date all through the year. So you don't have a lag, and then you don't have a buildup of changes that you have to make. The last thing I'll say is that I think tools can be helpful. If you are trying to monitor the law in a number of different states, and you're trying to make sure that your handbook is up to date with where you have employees, there are different tools that can help. That's something that we do at 650. We help companies to create their handbooks and then to keep them up to date. And the way that we do it is that we send out updates on a monthly basis, explaining, and this is a screenshot of one of our updates, explaining when the law has changed in different states and explaining specifically how we've changed our policies within our handbook. So a company can look at it and think, oh, actually, I do have something in Connecticut, and so I need to update my lactation accommodation policy, and it's already been updated in 650, so I can go in and make that change easily. Or sometimes we'll have something where there's been a change, but the change is already covered by our policy. And so having a service, and I know there are other great tools out there, but having a service to help can really make this a much more manageable process as companies strive to keep their handbooks up to date in these new challenging circumstances. So another thing that's very sort of in step with the handbook is the employment agreement. The two things kind of work hand in glove. And I'm going to turn the time over now to Adam to talk about implications for employment agreements when you have employees move to new states.
Thanks, Ryan. So as Ryan mentioned, we're going to transition now to talk about employment agreements. Ryan and Adrienne have given you all great information about considerations for companies that have remote workforces. Unfortunately, that's not the entire universe of considerations for those types of companies. And there are additional and specific things you need to be thinking about when it comes to employment agreements. So the first question companies often have is obviously which state's laws apply. And this is a question that's obviously been on a lot of employers' minds recently as employers are relocating and starting to work remotely in record numbers due to the pandemic. So answering this question is obviously really important. It's important to get it right. So I'm briefly going to cover this topic about which states' laws apply before diving into talking about best practices when it comes to approaching employment agreements for a remote workforce. But if you are interested in a deep dive on this topic, my colleague Marie Colbeth gave a great presentation recently, really going in depth on the question of governing law. And so that was in a recent webinar, and we will send that link around if you're interested, and we'll also include it in the follow-up email to this webinar. So one preliminary disclaimer for my presentation is that I'm just talking about which state's law governs employment agreements. As Adrienne mentioned, state law has a big impact on tax obligations, insurance requirements, leave requirements. And again, unfortunately for businesses, the state law that governs can be different based on which area of the law we're talking about. But for purposes of what I'm talking about today, just keep in mind that it's just specific to employment agreements. So what are we talking about when we say employment agreements? Well, it can be, it can include broad employment contracts that contain a wide range of contract provisions in them, or it can be sort of separate standalone agreements like non-compete or non-solicitation agreements, non-disclosure agreements, proprietary information and invention assignment agreements, and arbitration agreements. And with a few exceptions, state law is really going to be governing the enforceability of these agreements that you have with your employees. But with a dispersed and remote workforce, again, the question is, which state law do I need to comply with? It's really a complicated question, and very often it's not straightforward, but there is a general rule of thumb that will get you a lot of the way there. And that is that the law of the state where your employee is located is generally the law that you're going to need to be complying with in your employment agreements. So I've got a chart here that's hopefully helpful for you that gives some examples. So if your employee is working in person, it's easy, right? Let's say they always come into an office to work in New York. It's going to be New York law that governs your employment agreements. Even if they live in New Jersey and cross the border every day into New York to come to work, it's still going to be New York law that applies. If your employee is fully remote, it's also pretty easy to answer the governing law question there. It's going to be the state from which the employee is working that governs your employment agreements. So again, let's say you have an office or your company is located in Texas, but you have an employee that works exclusively from California, works remotely from California. The employment agreements are going to need, with that employee, or are going to need to comply with California law. If you have a hybrid situation where someone is working from home some of the time and from an office some of the time, it can get tricky. If it's the same state, that's not hard. It's the state, right, where they're located and where they work. But if they work from home a couple of days a week in one state and then come into an office a couple of days a week in another state, it gets really muddy. And the answer, you heard Adrienne mention nexus. Here, again, the answer often comes down to which state has the strongest connection or nexus to the employee. If the employee is doing almost all of their work in one state, but performing just incidental services in another state, like attending a conference or a client meeting, then the state where they're doing most of their work is probably going to be the state that governs. It gets a lot harder if they're providing substantial services in multiple states. It gets really tricky then, and that may be a circumstance where you want to consult counsel. Or another option is just to comply with the state law that's more strict, meaning more generous to the employee, because the company could potentially be subject to both states' laws in that circumstance. So in your employment contracts, a best practice is to always specify a governing law. Those are almost always included as a provision in employment contracts. But the important question is whether a court is going to enforce the state law that you have chose in your contract to govern. And sometimes courts don't let parties choose their own governing law. For example, in California, we'll talk about non-competes here in a minute, but in California, non-competes for employees are banned. In Texas, they aren't. So let's take that same example. If you're a Texas company, you have a California employee. Let's say you enter a contract with that California employee that has a non-compete provision, and in the contract you say Texas law is going to govern here. And so the employer may think, well, because I'm saying we've agreed that Texas law is going to apply, we can get around California's ban on non-competes. But if that non-compete provision is litigated later, the court almost certainly is not going to honor your choice of law provision there. Because the employee is located in California, California's non-compete ban for employees is going to apply. So again, the safest bet here is to make the governing law the state where the employee is located or performing most of their work. All right, we have another poll for you now. So we are curious whether your company uses non-competes, non-solicitation, non-disclosure, or arbitration agreements in multiple states. And so this is just a yes or no question. So I'll give you a few seconds to answer that, and we'll talk about the results we're seeing here. All right, the results are still coming in. I have a suspicion on the answer to this question, so we'll see if the results align with that. All right, just a couple more seconds, then we'll close it. All right, let's look at our results here. So about 58% of companies do use these agreements across multiple states. About 42% don't. I would suspect that this has changed. We would have gotten different answers a couple of years ago, right? As the way we work has changed a lot, and employees start to work more remotely from different states, and workforces are dispersed. And I would suspect that more and more companies in the coming years will probably answer yes to this question. But let's talk about some specific areas of the law that really highlights why getting the governing law question right matters. So let's talk about non-compete agreements first. So non-compete agreements, you probably know, are where an employee agrees not to compete with the employer for a specific amount of time and in a specific geographic region after their employment ends. They are notoriously hard to enforce, and non-compete varies greatly by state. It's really state specific. So For example, some states ban non-competes for employees completely, like California, which we talked about. States that do allow them have very different limits on how long a non-compete can last and how broad the geographic scope can be. There are 10 states that impose income thresholds, meaning that employers can't use non-competes for employees that don't earn X amount a year. This year, 10 more states are considering imposing income thresholds for non-competes, and a host of other states have introduced other forms of restrictions on non-competes. So it's an area of the law that's changing very quickly. And I think the takeaway for non-competes is that if you are using them, you should almost certainly not be using the same form agreement for employees in different states. And they really need to be state specific. So let's take a look at a hypothetical that demonstrates the importance of complying with the Wright state's law in your employment agreements. So here we have a company that's headquartered in Texas. An employee works in Texas and signs a 2-year non-compete agreement with the company that complies with Texas law. The employee makes $100,000 a year, but then during the pandemic, the employee relocates to Washington state. The company and the employee don't execute a new contract. 6 months after moving, the employee quits and begins working for the company's biggest competitor, which violates the terms of the original non-compete agreement that was signed. What's the result here? Well, under Washington's non-compete statute, which is very strict, the non-compete is going to be void because the employee doesn't meet Washington's income threshold of above $107,000 a year. And so, importantly here, the outcome would have been the same even if the contract specified that Texas is the governing law, because the Washington non-compete statute specifically says that companies can't get around Washington's limits on non-competes just by saying another state's law governs. If the employee is based in Washington, then the Washington law is going to cover that employee. And so in this hypothetical, not only can the employee now go work for the competitor, but the employer has to pay the employee's actual damages or a statutory penalty of $5,000, whichever is greater, and also cover the employee's attorney's fees, expenses, and costs for litigation. What could the employer have done here? Well, most importantly, they needed to be aware of where the employee was located. They needed to know that the employee was relocating to Washington. So the employer could have had a relocation or telecommuting policy in place that required an employee to get the company's permission before relocating. But once the company knew that the employee was relocating, it should have reevaluated its contract under Washington law, executed a new contract that complies with Washington law. In these circumstances, a company could, as a condition for allowing the employee to relocate, could say that a condition of allowing that is that you have to sign a new agreement because we're now going to have to comply with the laws of a different state. Then realizing that the non-compete didn't comply with Washington law, what could the employer have done? Well, if they really thought having that non-compete was important, they could have given the employee a $7,000 raise so that the employee would meet Washington's income threshold, or it could have decided to do without the non-compete and just rely on a non-disclosure agreement to protect its trade secrets and confidential information. So we're running up against our time here, and so I'm gonna. There are similar issues you need to consider when it comes to other agreements like non-disclosure agreements. The next slide is arbitration agreements. Really, the takeaway is the same thing here, right? If you don't comply with the law of the state where your employee is located, for NDAs, you may risk your NDA being unenforceable. For arbitration agreements, same thing. You may risk your arbitration agreement being unenforceable. And then similar for offer letters, I'll briefly touch on offer letters. There are some state requirements. We're starting to see this more and more, state requirements that for information that needs to be disclosed in the offer letter. So if you have a remote employee in Connecticut, for example, if you fail to disclose the wage range for the position for which the applicant is applying at the time of the offer, that can subject you to compensatory and punitive damages and attorney's fees and costs. And so this is a broader effort on the part of states that we're seeing to encourage and require wage transparency. If you're including a non-compete agreement or if you're having the employee sign a non-compete agreement, there are also notice requirements in several states, and an offer letter is a great place to put that, or else you risk your non-compete being unenforceable. And so just the takeaways here on the last slide: the best practices for managing employment agreements in a dispersed workforce. Don't use the same form employment agreements for employees in different states. If you do that, you're really at risk of having some important provisions of your contract rendered unenforceable. Second, keep track of where your employees are located. That's really important, obviously, as you can see from the examples that we've talked about today. You may want to consider implementing a relocation or telecommuting policy that requires, at minimum, that the employee provides you notice of relocation, but potentially consent to relocate. And then you may, once the employee relocates, you want to consider the law of the state where they're relocating and potentially sign a new employment agreement. So with that, I will leave you. And Ryan, I don't know if we have time for questions or if we have any outstanding questions.
You may have touched on this with your last bullet point, but we did have a question asking whether companies should consider having their employees sign new employment agreements when they move to a different state. What do you think about that question?
Yeah, I think that's definitely a best practice, right? As we've seen, if you don't do that, you're potentially subjecting a lot of your important contract provisions to being unenforceable. So if you have a non-compete agreement with that employee, and then they move to a state where your non-compete is banned, not only do you risk potentially having that non-compete be unenforceable, but if that state has a law that is very strict, you may even be subject to some civil penalties if you try to enforce that non-compete after the employee moves. So yes, I do think that would be a best practice.
Yeah, thank you, Adam. We are right up against the hour. We have had a ton of questions, great comments in the chat. In fact, I have loved watching people chat and answer each other's questions in there about payroll services and other things. This has been a really enjoyable conversation. We had some questions about the polls. I'll tell you that we had almost 200 businesses on the webinar, and we had above a 70% participation rate in a lot of those polls. And so we had, upwards of 140 respondents to some of those polls. And I thought that the results were interesting. We'll try to include those in our follow-up email. With that, we're at the top of the hour. We want to thank everyone who's joined us for the 650 webinar. There's been a lot of interest in this topic. As we mentioned earlier, we're working on a tool that will help companies as they have employees move to new states, and we'll be holding future webinars drilling down on some of these topics, and we hope that you'll join us for those webinars. In addition, we also provide tools that help companies with employee handbooks, employment agreements, returning to work, privacy compliance. And so if you are interested in learning more about our solutions, you can check us out at 650.com, and we hope you'll join us for a future 650 webinar. And with that, we'll sign off. Thank you very much.